It's time for Talk Law Radio with Todd Marquardt. Todd Marquardt, attorney at law in Texas. If you're a millionaire or a thousandaire, Talk Law Radio is now on the air. Call in with your business law question, your elder law question, veteran aid, Medicaid, build a business to get paid. 210-308-8867. Or ask a question online at marquardtlawfirm.com. That's MARQUARDT lawfirm.com. And now it's Talk Law Radio with Todd Marquardt.
Welcome to Talk Law Radio. I'm Todd Marquardt, on the radio, on Facebook Live, on YouTube, and on talklawradio.com. I'm here recording from my office, so you can see my diploma and my law license behind me, and that's going to be a little important today for today's episode. The question is, are you allowed to represent yourself in Texas probate? I'll talk about what probate is, and then I'll talk about a case study that explains whether or not you're allowed to represent yourself in Texas probate. Now it's time for you to discover your legal issue blind spots by listening to me talk about the law on the radio. Like I said, we're going to talk about probate, and you know that Marquardt Law Firm sponsors the show, and attorneys at Marquardt Law Firm focus on business and estate law, including last wills, living trusts, and tax-protected inheritance plans. Also, probate, guardianship, and trust administration. We're going to talk about some problems with probate. But first, I'm going to ask you a question. What do you think of when I say nothing can be certain except, that's right, death and taxes? So what must be done upon death? Well, if it's your death, you don't have anything left to do. But if it's a loved one that has passed away and you're sort of responsible for what happens next, you're going to call the funeral home or the police, depending on the circumstances. If your loved one was in hospice or in the hospital, or they were sick and they were expected to pass away, then you would probably call the funeral home. If you walk into your loved one's house and you think something fishy has happened, well, then you're going to call the police. Probably the next step is going to attend the funeral. If there's people that you expected to be at the funeral, but they're not, they might be at your loved one's home cleaning out his closet or cleaning out the furniture or the valuables. So I probably skipped a step. I probably should have said secure property before you go to the funeral home, because everybody knows that's where you're going to be. Of course, the funeral home is going to expect you to pay, so you want to make arrangements for that using either the deceased person's life insurance policy, or you're going to find some cash from their savings account, or maybe you're going to front the money first and then you're going to ask to be reimbursed later. The next step usually is when I get the call as a probate attorney, as a probate law firm, from somebody that says, what are the legal things that need to be done in order for me to wrap up my loved one's affairs and pay their bills and distribute whatever's left to the beneficiaries? There's going to be some sort of probate. Maybe there's another way. We'll talk about that at the end. But during the administration of the probate, you're going to be collecting income and assets that is owed to the deceased person, or that he or she already has. You're going to do what they call marshaling the assets, which is to collect all the assets under the name of the estate. You're going to pay bills, taxes, medical expenses, and legal fees. And then just generally, Don't take my word for it because every case is different. You need to hire a lawyer and get specific advice to your specific facts and circumstances. But then generally there will be a distribution to the beneficiaries. So what happens if there's no last will and testament? Well, that's what we call intestacy. That's the legal word for it. But if you're talking to an attorney, you should let them know whether there is a last will or there is not a last will. The lawyer will probably use the words intestacy. So in the Texas Estates Code, there's a section that says, if a person who dies intestate, the estate to which the person had title descends and passes in parsonary to the person's kindred in the order provided by this section. If you think that's hard to understand, I'm with you. Those are archaic words. Those are old words. That's not simple language. And so that's why it's hard for somebody that didn't go to law school to know what is exactly supposed to be done because of the legalese, as they say. So the thing about intestacy that is difficult, frustrating, and time-consuming is that if there's no will, then you can't name your executor and you can't name your beneficiaries. That all has to be done in writing on a last will. So if there's no will, then the state of Texas has a series of statutes that says who's going to inherit from you by default. That's part of intestacy. It's also part of what we call determination of heirship. An heir, H-E-I-R, is somebody that's related to you. And the Texas Estates Code says which relatives will inherit from you in a specific order, depending on your relationships and the like. What makes this difficult is that you have to prove who the heirs are with evidence, with testimony. You have to use the rules of evidence and the rules of civil procedure to present that evidence in court. And the judge is going to appoint another attorney to double check your facts. We call that the attorney ad litem. Ad litem is Latin. It means just for this case. And we don't necessarily know who the appointed attorney is going to be. So scheduling things with the court, with this other attorney, and with your own lawyer is going to be challenging just because we have to get all of those people together in the same place on the same day with you as well. So that's 4 different parties. You, your lawyer, the attorney ad litem, and the court all have to agree on a specific time and place to have the hearing. It's a little time consuming because some of the heirs might be hard to find. If these were estranged or distant relationships, they might be hard to find. And you have to have 2 disinterested witnesses to testify. People that are not eligible to receive an inheritance to say that they knew the deceased person so well, they knew when he or she was married, divorced, when he or she had children. And so I've had some cases where we had to find people in Mexico because they were children that hadn't been heard from in years and decades. Luckily, I have somebody on staff that was resourceful enough to know how to look for people in Mexico. So that's intestacy. What's probate like if you do have a last will? Well, what two things have to happen in order for a last will to be useful? Number one, somebody has to die. The person who wrote the will has to die. It's a death instrument. It's only useful for the probate purposes after death, because while you're still alive, it's really not a final useful thing, because you can always change it up until the time of death, or up until the time you lose the ability to understand what it is. And number two, the judge has to look at it and make sure that it's a valid document, make sure it's a valid last will. And the Texas Estates Code, again, sets out the statutory scheme of when is a last will valid. So the word probate sort of encapsulates that whole process that I talked to you about, wrapping up that person's affairs, paying the bills, and distributing what's left to the beneficiaries. But there are very specific steps, and that's why it would be good to have an attorney. Do you have to have an attorney? We're going to get to that when we talk about the case study in just a moment. Just want to remind you, I'm Todd Marquardt. This is Talk Law Radio, where I help you discover your legal issue blind spots by listening to me talk about the law on the radio. We're talking about probate of a will now. So the definition is, these are all synonyms: probate matter, probate proceedings, proceeding in probate, proceedings for probate, and they all include a matter or proceeding relating to a decedent's death. In Texas, there are 7 different court actions that can occur within a proceeding relating to a decedent's estate. Simply put, the term probate comes from the Latin word probare, which means to test or prove. One purpose of the probate is to prove the validity of the will, for the judge to make an official certification proving that the will is real. So some wills are not valid. And there's a good example of that. How many of you remember Howard Hughes, the famous test pilot and movie producer, played by Leonardo DiCaprio in the movie about his life? Well, the story goes that Howard Hughes had a mental illness later in life. I don't know whether this is true or not. This is just how the movie portrays him. I'm not making any statements about whether that's good or bad. Just setting the stage to let you know. Howard Hughes, it was said that he stopped carrying a wallet later in life. And if he needed money, he would just grab a scratch piece of paper and write out a will. There was a story about whether or not he had a flat tire. Go to the mechanic, told the mechanic, I don't have money, but I'm Howard Hughes. I can put you in my will. So he wrote out a will for him. Long story short, the estate of Howard Hughes was in a probate proceeding for 20 years. There was somebody who said that she was married to him when he died. There was a woman that said that she was his daughter. And so all of these allegations had to be decided by that court. And the long story is that a whole long list of his heirs are the ones that inherited a lot of his fortune. And then there was also a foundation that he started that received part of it too. But the reason I'm telling you all of this is because all you have to do is put this down on paper in a last will and testament, or another writing where you can make a testamentary disposition of your property upon death, is by using a living trust. So you can use either a last will or a living trust. I do recommend that you hire an attorney to do that because you have to use the right words. You have to follow the statutes. And how do we know what to put in a testamentary document? The word testamentary just means it takes effect after your death. I like to follow the proper definition of estate planning. This is where we get to control our property while we are alive, take care of us and our loved ones if we become disabled, and give what we have to who we want, the way we want, when we want. Furthermore, if we can, we want to save every tax dollar, professional fee, and legal court cost possible. Does that sound like a definition you could subscribe to? Show your family that you care. Discuss what you want to leave to who you want and the way you want on a testamentary document like a last will or living trust. It will reduce legal fees, taxes, filing fees, court costs, frustration, and it'll save time. It begins with meeting a professional attorney, estate planning attorney. I'm going to talk to you about a case study. This is a court case called Swain versus Dobbs. What happened is there was an auto accident and the executor filed a lawsuit against the insurance company. Well, the original lawsuit was filed sometime in 2015. In 2017, the district court dismissed the lawsuit because they said there had been no activity. They dismissed it for lack of prosecution. And then, so this, the person that filed the lawsuit filed an appeal. Well, it's called a bill of review in this circumstance. It's like an appeal. Well, the insurance company in 2021, this was 3 years later after it had been dismissed, and after this bill of review had been filed, they filed another motion to dismiss the bill of review for lack of prosecution. And the plaintiff had some friends that were trying to help the plaintiff prosecute the case. One of them was this person named Darren, who was like a disability advocate. The insurance company complained that there was no attorney representing this plaintiff. All they had was this disability advocate. And so the court said the number one issue to move the case forward or not, it can move forward with the plaintiff herself appearing in court pro se or appearing with an attorney, but not by the disability advocate. Either the plaintiff needs to be here arguing for herself pro se, or she needs to hire a lawyer. And why is that? Well, she wasn't just representing herself. She was representing herself as the executor. And so that's where we find a problem with this, because the executor represents the estate, another entity. The Supreme Court has stated that it has inherent power to regulate the practice of law in Texas for the benefit and protection of the justice system and the people as a whole. In Article 2, Section 1 of the Texas Constitution, it says the Texas Supreme Court can regulate the judicial affairs and the direction of the administration of justice in the judicial department. Within this authority is the power to govern the practice of law. The court's inherent power under Article 2, Section 1 to regulate Texas law practice is assisted by a statute, primarily the State Bar Act under Texas Government Code, Chapter 81. The Texas Government Code defines the practice of law as the preparation of a pleading or other document incident to an action or special proceeding, or the management of the action or proceeding on behalf of a client before a judge in court. Generally, a person may not practice law in the state of Texas unless the person is a member of the state bar. Texas Supreme Court can promulgate rules about who can practice. In addition, though an individual may appear in court either in person or by an attorney, a non-lawyer may not represent another party in litigation or on appeal because it constitutes the unauthorized practice of law. The Texas Rule of Civil Procedure 44 provides that minors, lunatics, idiots, or persons non compos mentis who have no legal guardian may sue and be represented by next friend. Plaintiff in this case was claiming that the disability advocate was acting as her next friend. However, Rule 44 does not vitiate Section 81.102 of the Texas Government Code, doesn't allow unlicensed persons to practice law through appointment as next friend. The plaintiff conceded in her brief that Darren, her chosen next friend, is a non-attorney. We find nothing in the record supporting contrary. As a non-lawyer, Darren is prohibited from representing another party in litigation or an appeal. So, if she really was non compos mentis, Darren could hire an attorney as her next friend. But then he would have an attorney. But the next friend cannot be the attorney unless the next friend is an attorney. I know that's getting confusing. So the court said, plaintiff attempted to perfect her appeal through bill of review in her individual capacity and in her representative capacity as executor of the estate. But the law distinguishes between a person in her individual capacity and the same person in her representative or fiduciary capacity as executor of the estate. This reminded me of a quote. A man who is his own lawyer has a fool for a client. Or, said another way, he who represents himself has a fool for a client. Now, that's often attributed to Abraham Lincoln, but the internet says that the proverb was in circulation long before Lincoln's time, and some sources trace it back to the 19th century English cleric Henry Kett. So why should you want to hire an attorney? Because of the rules of evidence, the rules of civil procedure, the rules that require somebody representing another person in court to have a law license and to be a member of the state bar. But just so you know, the lawyer doesn't necessarily always have to go to court. Probate lawyer can help you with more than just the probate court and the probate judge. We actually start helping someone when they call our office and let our staff know that someone has died. We begin with a checklist of questions to find out what kind of help is needed. If you're interested in receiving this checklist, email me at host@talklawradio.com. That's HOST @talklawradio.com, and I'll email you a copy just so you can see what kind of questions to expect. Well, I have to end this show for today, but thank you for listening. You can also listen on Saturdays at 11 o'clock in the morning. You can watch on Facebook Live, or you can watch on YouTube. Go to YouTube to subscribe to the Talk Law Radio YouTube channel. Just search for Talk Law Radio and look for Lady Justice and the red, white, and blue logo, and then click subscribe. So, are you allowed to represent yourself in Texas probate? No. Thanks for listening. I'm Todd Marquardt. I'll talk to you later.